introduce. I wish they would come up with a better way of doing that a little bit more discreetly.
Exactly.
Gosh, that's so annoying. Anyway, we're happy to have Greg McIntyre here from McIntyre Elder Law. Greg initially became a lawyer to fight courtroom battles, which he did for years. However, after working in an environment where the focus was always on the next billable hour, he started McIntyre Elder Law Practice because he was interested in being more than just a lawyer. Greg was interested in making a difference in his clients' lives. Being a husband and a father taught him what was really important in life. He takes pride in building trust with his clients and feels that they share the same values. He strives to help others leave a legacy to be preserved and to have a guiding hand in shaping their families' lives. Greg is a veteran of the United States Navy, that's for you, Brad, and a member of the North Carolina State Bar Association. He's a member of Elder Council, a national network focused specifically on estate planning and wealth preservation. He lives in Shelby, North Carolina with his wife, Stephanie, and their 6 children. So I wanted to say also that I heard about Greg from another Rotary Club, which gave you some really good reviews. So thank you for doing that. Without any further ado, Mr. Greg McIntyre.
Okay. Thank you. All right. So I'm Greg McIntyre with McIntyre Elder Law. I am a former Rotarian of the Shelby Club. It's the Cleveland Country Club, about 45 minutes west of here. I was born and raised, grew up in that area, and just have not gotten into found a new home here. And I love Rotary and the commitment to charity and charitable causes and all the work in the community that you guys do. So thank you very much for all you do. And thank you for allowing me to come talk. So what is elder law? I'm an estate planning and elder law attorney, which is kind of the same thing, but not really, okay? Estate planning and elder law. What do you think elder law is?
Helping with Social Security, probate matters, getting living wills established, and making sure that you have continuity of your estate going to where you want it to go.
And protecting.
Do you need a job? Do you want to do this? Right. Yeah. All correct. Absolutely. He started running down a list of, some of the things we do in our practice. So estate planning, I think, is a more general term where we're talking about, planning for things that happen during your life and beyond. Elder law is, a smaller subset of estate planning where we would be focusing on just a different phase of life where we're worried about, major things like long-term care costs. That's a huge one, right? You mentioned Social Security, right? That's always, from a financial planning perspective, especially, a thought of when do I take it, right? Do I take it early or late? Okay. Yeah. We hear that question a lot too. And Kevin, absolutely. When you're looking at doing estate planning documents, right? And you're talking about doing probate when somebody passes away or trust administration. So we have an estate planning department. We have a probate department, which I preach avoiding probate all the time, by far our largest department. Okay, so you can tell how many people actually listen to me. So seriously, you probably have over 300 cases you want statewide right now.
Yeah, wow. Living will.
Yeah, that is an estate planning document, okay? Which could be important to you, it could not. It just depends on you and your preferences, okay? And also a benefits department where we handle Medicaid benefits to help pay for long-term care while also protecting assets, even if people have not planned ahead and done their estate planning. And we do veterans benefits, especially veterans aimed attendance pension benefits. Do we have any veterans in the room or online?
Online. And in the room. Yeah, there are a lot of veterans.
Thank you for your service. Okay.
Thank you.
I'm a veteran service benefits as well, especially with veterans aid attendance pension benefits, which can help pay for assisted living or long-term care, or nursing home care or in-home care. So that's a little bit of a rundown of what elder law is from our standpoint. But I think people focus mostly on what happens when I die, or that's what they're thinking about. And I'm going to tell you that the majority of the issues we deal with or want to deal with are taking care of people and having them plan ahead to take care of themselves while they're here. Okay? So, let's start with foundational work. I'm going to cover quickly general durable power of attorney, healthcare power of attorney, living wills and wills. Okay? That's what I would call foundational documents, the foundational work. Some of those deal with you during your life. So what's a general durable power of attorney? General durable power of attorney. Also known as a financial power of attorney. Does anyone know?
It's a financial document that allows you to work on behalf of another individual while they're still living.
Agreed. It is a legal document that allows you, called a power of attorney, general durable power of attorney. It's general because it's covering most everything. Powers of attorney are extremely complicated. People don't realize it, which is why they draft them wrong all the time, even attorneys. So it's general in the sense that you want to empower someone else to also be able to handle any of your financial affairs, apply for benefits, move things around, whatever needs to be done to make sure you get the best care, to make sure that the band plays on, the bills get paid, everything can still be managed going forward. Okay? And it's durable because it survives incompetency, incapacity, mental disability, lapse in time. So you want to make sure it had that clause in there. Now, would you want to draft? So it also does not take any power away from you. You're just simply expanding and adding, say, an agent, is what it's called in the new statute, to handle your financial affairs for you when you need it. Okay? So if I appointed an agent, let's say my wife, or any agent that I trust, should you trust the person 100% that you appoint? No. Yeah, you should. You should. Before you open your financial affairs to someone else, needs to be someone you do not doubt. Okay? So you need to trust them 1,000%. And would you want to give them gifting power so they could gift money?
Well, trust them.
Would you want them to be able to benefit from transactions or from gifting? Move money in their own. What's that?
No.
See, he says no.
But if you trust them,
all right, so I'll put it a different way, right? And I get those types of responses, right? He's pretty confident in his response. Are you married, sir?
Yes, I am.
Okay. Let's say you married. Yeah. Kevin, this should be somebody else. Kevin invited me. Okay. So Kevin, is your wife on the call? No. Oh yes. Okay. So you trust each other, right? Let's say your wife is your agent, so that if something happened to you, heaven forbid, she can handle your affairs. Let's say she needed to move some money that was allowed under a benefit, say to pay for long-term care or something like that, to herself, to protect those assets. You would tell her that she can gift to anyone on planet Earth or move money or handle transactions, but she couldn't gift it to her account. Okay. And you would feel good about it.
I feel good about
it. Okay. But it could prevent you from receiving benefits that you may need. Okay. So you need to think about those things when you're drafting. Okay. You need to really think about those things when you're drafting. For me, my wife is my primary agent. Our oldest son is my secondary agent. He is 22 now and in law school. And always been a very straight agent. Okay, so I know he'll grow into that role. Hopefully he won't have to exercise that for a long time. And it would only be if my wife couldn't play that part, right? So you want to have subs to come in off the bench too, right? To play that role. If you have 2+ people in your life that you trust.
Not that other son.
Well, our other son graduates from high school tonight, actually. So I'll be at his high school graduation, and he's a great kid. Yeah. Yes.
You were actually doing estate planning, and you would want to have the ability to get perhaps lower the estate or estate tax purposes.
Well, right now the estate tax and death tax, you know what it is? 12, I think it's 12.08 for 2022. It's over 12 million per person, combinable to over 24 million per married couple. So if that affects you, I want everybody else to leave now. You and I are going to have a consultation. All right? You're my client. No. So that is an important consideration. I agree. Okay, estate and death tax, because that amount that I just talked about sunsets in 2025. So it would fall automatically down to, I think it's just over 5 million. And there could be other legislation that comes along at that time. We don't know what it would be, right? So it will fluctuate over time. There's a great document the IRS puts out. It's like 95 pages on the history of the estate and death tax. It's a really good read.
Was that part of the income tax reductions that occurred in 18, 19?
What's
that figure? You said it sunsets in 2025.
Yeah, well, it's fluctuated throughout my career.
Okay. From
600 grand to 1 year Bush was in office. There was 1 year where there was no estate and death tax. Wow. So if you had a lot of money, you wanted to graduate to the next level. That was
to die.
Yeah. That's right. So it does fluctuate depending on the philosophy of the administrations, who's in power at the time, who has the majority, and what they're trying to accomplish. Right. And then you see that reflected in that IRS report that I was talking about. So that changes over time. But you want to be aware of it, I agree. Trusts are great tools to double and maximize your estate death tax exemption, okay? So trust planning is the way to go there, because they can double that estate death. So, but really, a lot of planning hinges on the foundational documents and work. Because if laws change, or if your plan is not set up correctly, and something happens to you, and for some reason, if I had a stroke or a fall and I wasn't able to handle my affairs, my wife's in there and she needs the power to be able to do whatever she needs to do to make sure that our kids still go to college, that our assets are protected, that I get the best care, that we can pay for that care. And a lot of that hinges on whether I've made her my financial agent and given her the power to do that with a general durable power of attorney, and to make healthcare decisions for me, which would be under a healthcare power of attorney. Would it be important to appoint someone to make my life and death healthcare decisions when I am unable to do so? Only then. But I can appoint the person to do that. I have this picture in my head of my 6 kids trying to make a decision one day over what to do with dad in a medical situation. And I'm laying there. Maybe I need, I'm just thinking in my head, make a decision. And I don't know about your children, but mine couldn't agree on the color of that black case ring. And it's clearly black to me. But they would argue about it, and then they would be off in factions or rolling around the floor. And in my experience, sometimes families and children don't really act much differently in their 40s, right, or 50s. Maybe they argue a little more, in a little more sophisticated manner. I don't know, but still, I mean, we manage a lot of litigation cases as well, where we sue estates or overturn wills or trust or attack trust or defend them. And the reason is because, really, the family is arguing over what's been done, right? So with a healthcare power of attorney, I'm a big fan of appointing one agent, who I would relate that to be a quarterback, who huddles up with the family and runs that play in quickly to doctors, staff, administration. So there's great care and continuity of care. And if there's a disagreement in the family, I've appointed someone who can resolve that and be one clear voice for me.
Hey, Greg.
Yes.
Can't you stipulate that in your medical power of attorney, that if you're in a vegetative state, you take the decision away from your agent to just say, this is what I want to do.
So that's a living will.
Do not resuscitate.
Yeah. That's a living will, right? There's a lot there.
Yeah.
So So we'll get to that.
Okay.
So a healthcare power of attorney is where I'm appointing an agent to handle my affairs. I can appoint a backup. In addition, HIPAA would prevent anyone from getting your medical records that you haven't given authorization to do so. So I want to build in a HIPAA authorization within the healthcare power of attorney to allow my appointed agent for healthcare purposes to pull those medical records as well. That would be super important. Now, Kevin raised a good question. He said, can't I decide whether, how I would be cared for if I was in a persistent vegetative state? Then he mentioned something about a DNR. So that's a living will. It's what he's referring to, which is a separate estate planning document. It's better known as, it was named by some dumb attorney who wanted to make it sound good and confuse people, because it's not really about living, and it's not a will that passes assets where people confuse it. They're like, I don't need to do estate planning, I've got a living will. Okay, well, that document is a declaration for a desire for a natural death. That's what it is, and that's what it does. It says, if I'm terminal, incurable, in a persistent vegetative state, if the only medical procedures that can be done for me are going to prolong my suffering, is it okay to let me go? It's my voice in the room. It's both a legal and a practical document. So it tells my healthcare agent, doctors, hospital staff, that if I'm in this situation and there's no return, it's only downhill from here no matter what's done. Or if I'm in a persistent vegetative state, perhaps my body could be maintained, for example. We see those Terry Schiavo situations. Those are rare, I think, but every once in a while. It would be my answer to that situation saying, hey, it's okay in that situation to let me go. Very different from a DNR. I got 6 kids. If I have a heart attack right now and I fall down on the floor and I have a DNR taped to my chest, then technically they shouldn't resuscitate me. Please bring me back because daddy's got to work, okay? A living will, also known as a declaration for desire for a natural death, is not a do not resuscitate order. That is a medical document that you would work out with your physician. Lots of times you see folks who have gone through treatments, have maybe been brought back before, or at the end, and they said, hey, I've had enough, doc. If I code again, if my heart stops, I stop breathing, do not bring me back. And that is a medical document that you would negotiate and sign with your medical doctor. That is not a declaration for a desire for a natural death and not a living will, okay? A living will is a practical document also. It's a practical document because I'm not laying on the shoulders of my wife or my 6 children the sole responsibility to make the decision whether to pull the plug on down. I'm telling them, if I'm in this situation, this is the way I want it handled. I happen to think that'd be a tough decision. And if you've ever had to make that decision for a family member or loved one, I'm sure it sticks with you. It's one that can haunt you. So a living will, that's what it is, okay? Both a legal and practical document. Okay?
Where does organ donate? Where does organ
donation go? In the healthcare power of attorney. A healthcare power of attorney is where you can choose to donate any needed organs or parts, or just specify what organs or parts you would like to donate. We're getting morbid now, huh? Yeah, just my left pinky, okay? This is my best feature. I don't know, but you could certainly specify that, right? Or limitations on burial. The agents you appoint in a financial and healthcare power of attorney, do they have any power when you die?
Financial does. Well, they're not the executor of the will. Yeah, they're not necessarily the executor of the will. Not necessarily.
So financial has no power. It ceases to have any legal significance when you die. Okay? And then you would need some other authority to be able to transfer assets, such as beneficiaries of life insurance policies can file claims, or other assets that need to change title, like a home that's not in a trust. The term beneficiary comes from trust, not from insurance companies, okay? It comes from lawyers drafting trust. Take pride in it, all right? Been doing it a long time before insurance companies decided we wanted to add beneficiaries, okay? So if an asset like a house, any bank account, any investment accounts in a trust, you have beneficiaries, and your trustee would administer. Not a power of attorney. You cease to have any power on that financial side. Or if a house or other real estate's hanging out there, that's what would flow through, say, a probate, estate, or estate administration. Testate or intestate. Testate's with a will. Intestate, the state has a will for you. The statutes of intestate succession, where I know we all trust all our elected officials, and they've decided exactly what's going to happen to your money problem. Okay? That's right.
That's why you should vote.
Or get a will. Get a will. Yeah. Maybe handle it yourself. Yeah. So yeah, take personal responsibility. Yeah. So anyway, yeah. So your executor would have to qualify, right? Apply to the courts to be the executor, get qualified to then have access to transfer title to, say, bank accounts or other real estate that needed to change title through that probate process, right? Agreed. Healthcare power of attorney, the only power that survives death is the agent that you appoint can handle burial. So you could qualify. Some people are particular, cremation only. Some people say no desecration of the body. It depends on what your thoughts are, your religious, your religion, right? Living will is a place that you might want to put specific religious requests. My Catholic class, we do a Catholic living will that I drafted for a priest, and I've drafted for nuns. You would want last rites, Eucharist administered prior to being let go, and want to specify everything should be done in accordance with Catholic teachings. And all of us have our particularities with our religions that may be important for us to place in a document like a living will. Okay. So then we get to the will. I get that Larry the Cable Guy question all the time. Hey, you need wills? Yes, I do. I'm a estate planning and elder law attorney. Yes, I do. And also, I have people say, hey, they don't know what probate is, so they say, I don't have to go through probate because I have a will. And that's interesting because probate, you might know what probate is?
Like a holding period after death.
Probate is actually the court process by which a will passes property. It is what a will does after you die. A will has no power. It is not worth the paper it's written on until you're dead. Okay? And only if it's then submitted to the courts for probate, or else it just sits there. Okay? Your executor has no power unless they qualify and apply to be the executor.
Can you? I do it because I'm the executor of a couple wills. Thank God I haven't had to.
Like racking them up.
I haven't had to step up to that one yet.
Yep.
But I'll tell you,
yeah.
I think they only gave it to me because my sister couldn't afford to hire a lawyer. So
sure.
Can I hire a lawyer to execute that? And if it's not, like, I don't really want the responsibility.
And that's called an administrator CTA. So So you could sign over and relinquish your right to be the executor. If there's a secondary executor, they would have to do the same thing, execute a waiver and maybe a bond waiver, things like that. So that, say, for me or one of our attorneys, for example, could be the administrator CTA to oversee that step and move that along in a time.
Or Kelly, the trust department in most banks would be able to do the same thing. They'll do a lot of the work for you. At least in the private.
Okay, so yes, you can have a third party. You can have an attorney be an administrator CPA, or you can qualify as the executive, and you can hire an attorney to generate all the paperwork, guide you through the process, give legal advice, right?
Okay,
you
right,
do
that
that
makes
too.
sense.
Yeah,
Okay.
either way. It can go either way. That's true. No. Yes. So yeah, probate is that process by which a will changes title to asset. Is a will the best place to pass our property?
Trust.
I mean, they've been around for thousands of years, literally. And I think pretty sure they talk about them in the Bible, like the Old Testament. Greeks had spoken wills. Romans had like a council of 7. I'm sure that worked out great. 7 people heard something 7 different ways, and all argued over it when somebody died. So wills have been effective ways. I'm not here to bash wills because they are effective ways to pass property. The danger with a will is there's several. One is lawsuits, right? So somebody contesting the will. So whether someone was competent when they signed it, whether there was undue influence from a family member when somebody brought them to an attorney's office and lorded over them while they talked to the attorney, and that's my job to kick those people out of the room, really politely, as politely as possible, right? Hey, could you wait in the lobby? Because I don't like the way you're lording over this person and answering all their questions, right?
Just put your gun away.
Yeah. So I mean, there's problems, some problems with wills there with litigation. Also, claims against your estate. So where we see people lose houses when they die, things like that, and they don't stay in the family, it's really in long-term care situations. I mean, long-term care, it's hard for a lot of folks to save enough money or get enough insurance or whatever they have to pay enough income to provide long-term care for themselves for any period of time. So it starts sucking down all the assets. Or maybe, maybe they roll to a benefit like Medicaid to pay for that. And then Medicaid, say, files a claim on that estate during the claims period. So when you file a will, probate an estate, you have to advertise in the paper for 4 consecutive weeks. And then from the first date of publication, it starts the 90-day claims period, where we're really on pause. We just sit back and don't do anything because there's nothing to do. We're waiting on any claims to come in. And then we go check the court file after the 90-day expiration to see if any claims have come in. And we can't spend out any money from the estate or transfer anything really to the heirs during that period. We have to, because there's a hierarchy of how claims have to be paid first. If the state, say Medicaid, files Medicaid collections, files on the estate, or
IRS.
IRS. Well, tax lien state. IRS tax liens are top priority in the hierarchy of payback. But yeah, there's all kind of liens that could Visa, MasterCard, right? All those things attach. However, life insurance beneficiaries, IRA, 401k beneficiaries, those things transfer outside of the probate estate and outside of the ability for the state or for anyone to collect or levy claims against. Okay. So you can set up assets to avoid the claims period and also to transfer much more easily than the probate estate. So there's pluses and minuses. It just depends on your situation. You may want to, there may be reasons you might want to do trust plan. You know what trusts are? I'll show you what a trust is. Is this an empty? Has money.
This one's empty.
Okay, give me one. I don't want anybody to claim I stole $4. So, I don't want the responsibility. So, okay, this is a trust. It's a Rotary trust. So it's very representative of what a trust is. Okay, it's a vessel. It's a legal vessel that we would create, or a legal fiction. And I'm going to talk about two different types of trust: revocable and irrevocable trust. This is a revocable trust. It's mine. I created it. I'm the trustee. A trustee is the person who is over the assets in the trust. As the grantor, also called the trust maker and the trustee, I can put anything in the trust I want to, any investment accounts, real estate, and I can take them out. This trust will hold any number of those, an infinite number. And I'm in control of it. I can break the trust or revoke it. Throw it down, right? Break it.
Can you co-share it, like with spouse?
You could create a family trust where it could be a trust for both of you. That's correct. And you're both co-trustees. Yes, absolutely. And because I'm in control of it, with some of my clients, that's a factor because they're worried about protecting assets in long-term care. The government, so Medicaid, would deem this as my asset because I control it. I'm the grantor, the trust maker, I'm the trustee. Could you come join me, please?
Absolutely.
Thank you. I want you to hold my trust. She is now my trustee. This is an irrevocable trust. It can still hold any infinite number of properties or accounts. My beneficiaries are still set to go to my children, grandchildren, whatever. Maybe outright, free of trust when I die. Or I may not want to curse a young child at 18 with a lot of money. I don't know about you, but I would have done stupid stuff with $1 million at 18 years old. Yep. Done. It would have been gone by 19. And it would have been somewhere redneck. I would have been in Myrtle Beach.
It's getting better.
Myrtle Beach. I love Myrtle Beach back in the day. So I've been there lately. So with like some kind of 4-wheel drive Lamborghini or something, going down the strip, it would have just been, I mean, you might want to let somebody like me get some more life experience. Maybe join the military and go around the world for a while. Get some education, right? Maybe help fund that in a discretionary manner until they're, say, 25. And then give a percentage out each year for the next 10 years. Okay, maybe 10% a year for the next. That's an example of a distribution we would set up for grandchildren or children that maybe aren't of age, right? Aren't 18. So trusts are really good for letting you write your story over time. Okay? And because she's my trustee, and we made it an irrevocable trust where I can't revoke it, I can't destroy it. I can put whatever I want to in it, but I can't take it out. You can direct where it goes. I might give you certain powers, but I can't. Okay? I'm going to divorce myself because I want to start a 5-year look-back period for nursing home Medicaid, or a 3-year look-back period for special assistance that pays for assisted living care. And maybe I want to create I'm going to get in the weeds, an intentionally defective grantor trust where I can still draw income off 10 rental properties I have in there if I want to. But you have ability to cut off that income if you need to, so that I can qualify for something like a Medicaid benefit to pay for my long-term care.
Or Medicare. Instead
of having to sell off all my rentals.
Would you still qualify for Medicare?
So Medicare is different. Medicare doesn't pay for long-term care. Medicare, everybody over 65 has Medicaid.
Oh, Medicaid. So that's right. Medicaid is financial. When you hit a certain threshold financially.
Many different types of Medicaid. Special assistance is not Medicaid, but is a program that pays for assisted living care. It has a 3-year look-back period for transition of assets to an irrevocable trust or other ones. And there's special rules behind that. Our benefits department deals with that every day. Or long-term care Medicaid pays for nursing home care in North Carolina, and it has a 5-year look back for this.
Oh, I know. I've been through it.
However, I mean, we help people in a pinch too. We call that Medicaid crisis plan. The rules are crafted such that there's so many ways to protect all the assets and still get the benefit if you need it. It just depends. And that's what we did. And that's
Which one?
That's part of that. That's a good culmination of what we did. Okay. Thank you for your help in being my trustee. I appreciate it. Okay. You're very good. I can tell you're very theatrical. Okay. Oh, yeah. You remind me of my 8-year-old son. He just won like the acting award for his high school this year.
I was a theater teacher. For
I knew it when you sang earlier. I knew there was that.
We have to.
I said that in my head. I said that in my head. I love that.
Hey, they elected me, so.
Hey, I've never been accused of being shy either.
Their fault.
You had a question.
A moral dilemma.
Okay. What's your moral dilemma?
Hugely clever and smart to put everything in trust so that the state would pay for your long-term care and your assets go to the children.
Yeah.
Very intelligent way to do that.
Could be, maybe not. Maybe the assets are there or we can structure them and set up to pay for. Another way of planning and another way to go is to make sure that long-term care insurance in place or some form, maybe a hybrid. Maybe there's $1 million in retirement assets and we want to use 100,000 of qualified funds to put it in a One America asset like long-term care plan that pays off 3 to 5 times as much as you put in for long-term care. You can share with your spouse. So you sacrifice a little to save the whole, or you can call it back anytime you want. You're really not sacrificing, it's still there. I mean, there's many ways to set that up. Yes.
Back to, aren't you in fact cheating the taxpayers who are then going to support you through Medicaid?
Yeah.
Even though you have a pot of money over here that you wisely put
yeah.
over there.
Yeah, and you should spend out all your money. Yeah. And have nothing when you die. Right. There's a lot of ways to look at that. I can spin it a different way. You know.
Well,
yeah.
That's a very clever way.
Well, let me ask you. Well, what the clever way is for the government to take all the money to do your life, and you feel, and that's the trick that most of the middle class falls into. Yeah. And then they feel morally obligated to spend out all their money, and let's say lose their house in the end. Number one, you know, you got taxed on your money when you brought it home in a paycheck. Number two, right, quite heavily. Number two, you took that money and you paid the bank about three times as much as you borrowed. Like, let's say you bought a house for 100 grand. Pay about 300 grand over 30 years. And then in the end, and you also paid taxes on everything just to breathe during life, including income taxes. Everything you buy, your lunch, everything else, right? And then in the end, you feel really guilty. And you want to, and so you give up your house, right, or sell it to pay, and then go out with zero. And that's the way a lot of people feel. And I respect that. I just don't know if I agree with it.
On the other point is too that when you're Medicaid, you don't choose where you're spending your last days.
Okay, that's a good question.
You do.
The answer is this. Here's what we found. Taylor, what percentage of nursing homes? She used to run our Medicaid department. What percentage of nursing homes have both private pay and Medicaid? And by the way, if you know me, I would rather see everybody be able to private pay. And that's my goal when we sit down, is to look at that as an issue and how can we protect the assets while also giving you all the freedom. I would rather not. Who wants to go to a nursing home in this room? Am I the only one? No, nobody wants to go. Yeah. So right. And then you have a system set up on the back end that's set to take it all back, right? Yeah. So you're up against that system.
That do accept, they have Medicaid like rooms and beds. It's the exact same thing. It's just a certain percentage. It's almost like affordable housing.
I would rather have in-home care. And I would rather have either the income already set up to pay for that in-home care or some kind of hybrid plan like I spoke about to make sure it activated and gave the extra income to pay for that care, which really acts as a protective tool, okay? Absolutely. And what percentage of nursing homes in the area, by the way, would you say accept both private pay and Medicaid?
they would rather have, I would say most people would rather have private paid Medicaid.
No, I think I maybe asked that wrong. In our experience, probably over 95% of the nursing homes in North Carolina take both. Okay, they take both. That was what I was saying.
Because they'll take all your
money,
take both,
and
then they switch you to the
that's right. So it's either way. So you're receiving the same care in the same place.
But they also it also takes. So I only know all this because my dad's been in the long-term nursing care for years now.
Sure.
And we had to apply for Medicaid because he ran through all of his money so fast in all the nursing facilities and the hospitals and everything. And they take all but $32 of his Social Security to pay. So he doesn't even get his Social Security check anymore. So like you can say that Medicaid is paying it, but it's really not. He's just losing his Social Security money.
Well, that's his PML, his patient monthly liability, which is his non-divertible income that's allocated to be paid every month and just has to be to the nursing home minus $30. He gets to keep $30.
Yeah, which doesn't even pay for
$30 a month. That's right. Yeah, so I would agree with you. It's a complicated problem and a political issue. I know where I stand on it, okay? But I respect where other people stand on it too. I've been fighting the man since the day I was born and continue to do so till the day I die. And that's just me, okay? Go ahead.
We're getting ready to leave.
Yes, sir.
To her, because I have another meeting, but because her moral stance or dilemma, I'll explain it the best way my grandfather did to us.
Sure.
He was getting ready.
Yeah.
You guys want me to give it to Congress, or you want me to give y'all this farm?
Yeah.
There's no issue after that.
I mean, the way the system's set up right now, it would be to give up the farm. That's why I wrote a book, 2016, called Saving the Farm. That was a bestseller in its category on Amazon. By the way, thank you.
And we still have the farm.
Yeah, save the damn farm. Take care of you, Barbara.
Take care.
All right. That's I'm changing the name. That's for it.
I have a scenario that's a little different than what we're talking about with assets right now. It's actually about protecting right now.
Sure.
I have an older client who is, I don't know if she's having a lot of memory problems, but she has assigned 2 power of attorneys. And we have been working with her. Every spam call she gets, she falls.
Yeah.
Thankfully, she comes to our office and our office knows her and we don't give her her money.
Yes.
But her power of attorneys have now had to take away her right to her money because she keeps getting it. They've had to go back and ask them for guardianship rather than power of attorney.
Yeah.
Because
sometimes guardianship is the right answer. And guardianship is a court proceeding, right? Where a guardian, somebody applies to be the guardian. The problem with guardianship is the person appointed to be the guardian, especially if there's conflict in the family, may not be the person you want. Or it might be some dumb attorney, you know?
It's a little difficult because she comes in and sometimes the person's still on the phone telling her that she needs to get cash. We'll give you a cashier's check, maybe payable to your medical bill. She said, well, I can't tell you what it is. Or the next time she's like, I have a legal issue, but I can't even tell my boyfriend about it. So
to that point, I'll tell you, I've super enjoyed my interaction, especially with your point. We need to talk after, okay? And by the way, I have clients of all across the strata of socioeconomic positions. It's like, you know, I do, and I have for years. We have 5 attorneys. We have an office uptown, Shelby, North Carolina, which is my original hometown, and Hendersonville, which is a huge retirement area right outside of Asheville. So we kind of cover Western North Carolina. I love what I do. I could talk about this all day, but I have to go serve my clients this afternoon. Okay. I very much appreciate you having me out, Kevin, and you guys, and for your questions. And if any of you would like to talk further with me or my office, what I do is I offer a free consult to anybody who can. Okay. You know, give us a call or get with Ms. Taylor over there. She's great with setting that up. And what I like to do is just sit down and say, hey, what are your goals? Right? I mean, with me, I'm just kind of just a tool. I hate to say that because that has a background. I'm just a tool.
Oh, that guy, he's a tool.
Yeah, I am a tool. But what I mean is I'm your tool, and I'm, it's about what your goals are and what you want and helping you achieve those. Okay. And through usually, sitting down and talking about assets, family, we can really, flesh out what your goals are and try to help you achieve those. That's what elder law and estate planning is. And I appreciate you letting me come. I'm Greg McIntyre with McIntyre. Thank you. Have a great day. Yes. Thank you very much.
Conduit.
Yes.
That's better.
Oh, okay. I'm a conduit. I need to.
Yes.
Yeah, there's not much money to stay on the floor.
Hey, Taylor. Nice meeting you. Thank you for getting him here.
And we'll let him actually eat some food before he runs off, and we have a classy mug for you.
Oh, thank you.
Yeah, so we'll here.
We got to do the.
And we're gonna do. Can you just, while you're standing, can you just do a little drawing for us?
Yes, I will.
Take any ticket out of there, and just read the last four numbers.
And the numbers are 4475.
Bingo, we got it.
Right here.
Oh, excellent.